Understand the reality. Workplace abuse is often strategic. Many toxic workplaces operate because employees are financially dependent, afraid of retaliation, unsure of their rights, emotionally exhausted, socially isolated. Adult workplace bullying often includes repeated humiliation or targeting, unrealistic workloads meant to force failure, exclusion from communication, gaslighting, saying things like, that never happened, threats disguised as feedback, intimidation meant to provoke emotional reactions. Abuse continues when there is no documentation trail. Bullies frequently rely on lack of proof, emotional reactions instead of records, private conversations with no witnesses. Shift from employee mindset to case building mindset. HR is not your personal advocate. What HR actually does: human resources exists primarily to protect the company from legal liability, ensure policy compliance, reduce risk exposure, document internal issues. HR may help employees when helping the employee also protects the company. Why immediate HR reporting can backfire. If someone reports too early without evidence, complaints may be labeled interpersonal conflict. Management gets alerted before evidence exists. Retaliation may begin subtly. Documentation may start against the employee. HR is a legal department in a friendly outfit. Prepare before reporting, not avoid reporting forever. Documentation, your most powerful protection. Daily documentation method, very practical. Record immediately after incidents. Include date, time, location, who was present, exact words spoken, quotes if possible, your response, witnesses, emotional or physical impact, any policy violations. Example entry format, March the 3rd, 2026, 9:12 a.m. Break room. Supervisor stated, you're too slow. Maybe you don't belong here. Witnesses: John D., Maria S. felt intimidated and singled out. Work assignment changed afterwards. Rules of documentation. Write facts, not opinions. Avoid emotional language. Record patterns, not just big events. Save emails, text, schedules, performance reviews. Screenshot communications, if legal in your state. Patterns prove harassment, not single incidents. Understanding HR timing. Why strategy matters. Many employees believe that reporting workplace abuse to human resources immediately guarantees protection. In reality, timing and preparation can significantly affect outcomes. This guide does not discourage reporting. Instead, it encourages strategic reporting, understanding when reporting helps your case and when it may unintentionally weaken it. The reality many employees learn too late. Human resources departments serve an organizational function. Their primary responsibility is to protect the company from legal and financial risk. Because of this, HR investigations often focus on whether company policy was violated, whether legal liability exists, whether the company can demonstrate it responded appropriately. This means the quality of evidence matters more than the emotional seriousness of the situation. Employees who report without documentation may discover complaints characterized as personality conflicts, lack of corroboration used against them, investigations close quickly due to insufficient proof, workplace relationships changing after reporting. For many workers, this becomes the moment they realize that preparation matters as much as reporting. Why some employees wait until later in employment. Some individuals choose to delay formal HR reporting until they have documented repeated patterns of behavior, preserve emails and communications, establish consistent professional conduct, gathered medical or counseling documentation, secured financial or employment backup plans. The reasoning is simple. Reporting creates a record, but preparation strengthens that record. When a complaint includes months of detailed documentation instead of a single incident, credibility increases dramatically. Understanding reporting time limits. Many companies have internal reporting timelines written into policy manuals, such as requiring prompt reporting, limiting investigation scope to recent events, emphasizing timely notification. Employees should understand internal timelines are company policies, not always legal deadlines. External agencies may have different filing windows. Documentation preserved privately can still support later claims. This is why maintaining personal records from day one becomes essential. Workplace bullying often operates in groups. A difficult reality discussed by many targets of workplace bullying is the presence of social dynamics or cliques. Common patterns reported include a dominant personality acting as an informal leader, group loyalty overriding individual disagreements, coworkers supporting one another during investigations, coordinated narratives during interviews. Even individuals who privately disagree may publicly align to protect group stability or avoid becoming the next target. From a case building perspective, this means witness testimony may not always be neutral. Popularity does not equal credibility. Written evidence becomes more reliable than verbal accounts. The leader dynamic. Many bullying environments develop a hierarchy. The leader sets the tone, initiates the behavior. Enforcers participate to maintain status. Bystanders remain silent for self-protection. The leader often avoids direct violations while influencing others indirectly, making behavior harder to prove without patterns documented over time. Recognizing this structure helps employees avoid taking incidents personally and instead view them strategically. Why emotional support inside the workplace can be risky. It is natural to seek comfort from coworkers during stressful experiences. However, workplace conversations can unintentionally become rumors, misquoted statements, investigation evidence, testimony that contradicts your documentation. A safer approach is to seek support from trusted friends outside the workplace, licensed counselors, support networks not connected to the employer. The strategic mindset. Instead of reacting immediately, employees may benefit from adopting a structured approach. Observe, document, stabilize, prepare, report. This mindset shifts focus from emotional survival alone to long-term protection. This guidance reflects lessons learned through personal experience and observation. Every workplace and legal situation is different. Readers should consider consulting qualified professionals when making decisions about reporting or legal action. In toxic workplaces, survival isn't about winning arguments, it's about preserving evidence. Limit conversations. Why silence protects you. Many people unintentionally damage their own cases. Why not confide widely at work? Co-workers may repeat conversations, be pressured by management, unknowingly contradict your account, become witnesses against you. Toxic environments often test loyalty. Guideline: only discuss issues with supervisors strategically. Licensed professionals, legal counsel, official investigators. Comfort conversations can become evidence. Always assume you are building a case. Employees should think every interaction may matter later. Consistently build credibility. Professional behavior protects you. I encourage you to stay calm publicly, avoid arguments, communicate in writing when possible, confirm verbal instructions by email. Example: per our conversation today, I will complete X by Friday. This quietly creates a paper trail. Police reports: understanding consequences. When police may be relevant. Threats of violence, stalking, assault, harassment, outside workplace boundaries. Things to understand. Filing a report escalates situations. Employers may respond defensively. Investigations become formal and permanent. Document first. Seek legal advice when possible. Understand local laws before filing. The goal is informed action, not emotional reaction. What the EEOC does. The Equal Employment Opportunity Commission handles claims involving discrimination, race, sex, religion, disability, age, etc., harassment connected to protected classes, retaliation after reporting discrimination. What EEOC does not do. Resolve personality conflicts, fix general toxic culture alone, act instantly. Process overview. File a charge. The deadline is usually 180 to 300 days. Investigation begins. Mediation may be offered. Employer responds. EEOC may issue a right to sue letter. Documentation greatly increases credibility during EEOC review. Protecting income, unemployment strategy. Many people wrongly believe quitting means no unemployment. Constructive discharge, working conditions become intolerable, hostile environment evidence, medical documentation supporting inability to continue, helpful actions, report issues internally at least once strategically before you quit or after dismissal. Keep performance records, maintain attendance, obtain medical or counseling notes if stress related. Consistency matters more than dramatic incidents. Understanding unemployment, why documentation protects your income. One of the hardest realities employees face in toxic workplaces is this: losing a job is not always the biggest risk. Losing income afterward can be. Many employees assume unemployment benefits are automatic after termination. In practice, eligibility often depends on how and why employment ended and what evidence exists. Why companies may resist unemployment claims. Unemployment insurance is funded through employer payroll taxes. When former employees successfully receive benefits, it can affect the company's unemployment insurance costs and internal reporting metrics. Because of this, employers may carefully document performance or conduct issues when conflict arises with an employee. This does not mean every employer acts unfairly. However, employees should understand that workplace disputes can become documentation contests. Whoever has the clearer, more consistent record often carries more credibility during unemployment review. The risk of becoming the problem employee. Employees who repeatedly report concerns without strong documentation may unintentionally face a narrative shift. Common outcomes reported by workers include being labeled difficult or disruptive, increased scrutiny of performance, sudden disciplinary write-ups, isolation from teams or communication, termination framed as performance-related rather than environment-related. When multiple coworkers align against one employee, it can create the appearance that only one person is complaining, therefore, the issue must be the employee. This is why evidence matters more than popularity. At-will employment, what it means for workers. Many states operate under at-will employment, meaning an employer can terminate employment at any time for almost any lawful reason. Important distinction. Employers do not always need to give a reason, but unemployment agencies still examine the true circumstances surrounding separation. Termination alone does not automatically disqualify someone from unemployment benefits. The deciding factor is often whether misconduct occurred and whether documentation supports the employer's claims or the employee's experience. How documentation changes the outcome. Your case demonstrates a key lesson. Documentation transforms personal experience into verifiable evidence. Useful records may include daily incident logs, saved emails or messages, performance reviews showing satisfactory work, schedule changes or disciplinary patterns, medical or counseling documentation showing stress impact, written attempts to resolve issues professionally. When documentation shows a pattern of hostile conditions or inconsistent discipline, unemployment reviewers may view separation differently. How unemployment decisions are often made. During unemployment review, agencies commonly examine reason for termination or resignation, prior disciplinary history, employer policies, communication records, consistency between both parties' accounts. This is why emotional explanations alone are rarely enough. Clear timelines and written evidence carry significant weight. I learned through experience that workplace conflicts can quickly become documentation battles. I was able to receive unemployment benefits because I kept records consistently. My documentation showed patterns that could not easily be dismissed. What felt overwhelming day to day became clear when written over time. Strategic mindset. Protecting yourself while still employed. Employees who suspect a hostile environment may benefit from focusing on 3 goals simultaneously: maintain professionalism, preserve income eligibility, build factual records. Practical habits. Follow policies carefully, avoid emotional confrontations, confirm instructions in writing, maintain attendance and punctuality, respond professionally even under stress. Consistency helps prevent employers from reframing the situation as misconduct. Unemployment cases are rarely decided by who suffered more emotionally. They are often decided by documentation, credibility, consistency, timelines. This is why preparation while still employed matters more than actions taken after termination. When conflict begins at work, you are no longer just working a job, you are protecting your future income. What helped me win my unemployment case? I documented daily, I stayed professional, I avoided workplace gossip, I saved written communications, I focused on facts, not reactions. Using benefits while still employed. Use employment assistance programs, EAP, mental health counseling, medical visits documenting stress symptoms, PTO for recovery when needed. Medical records can demonstrate emotional distress, anxiety symptoms, physical effects of workplace condition. These records may later support claims or unemployment eligibility. Outside counseling and medical documentation. Professional documentation carries weight because it is neutral, time-stamped, medically recognized. Say factual statements like, I am experiencing ongoing workplace stress affecting sleep and health. Avoid exaggeration. Credibility is everything. Social media, why silence is protection. Explain risk. These are the risks. Please pay attention because this is so very important. Posts can be monitored. Emotional posts undermine professional image. Employers may screenshot content. Prayer or motivational posts can be reframed as instability or conflict. Avoid discussing workplace issues online. Consider temporary deactivation. Assume anything public may appear in court. Adult bullying psychology. Workplace bullies often seek control, reactions, validation through dominance, targets perceived as empathetic or non-confrontational. They rely on your fear of job loss, social pressure, and isolation. Bullying continues when targets react emotionally instead of strategically. Emotional survival rules. Stay polite, not personal. Reduce emotional disclosure at work. Focus on financial exit planning. Separate identity from job role. Build support outside workplace. Using unemployment as a recovery and rebuilding period. Unemployment benefits are not just financial assistance. They are meant to provide stability while you transition into healthier employment. Many people feel pressure to rush into the next job immediately. However, when leaving a toxic environment, strategic use of unemployment can help you recover emotionally, strengthen your case if one exists, and position yourself for long-term success. Understand the purpose of unemployment benefits. Unemployment insurance is designed to replace partial income temporarily, allow time for active job searching, prevent financial crisis during transitions, support re-entry into the workforce. It is not a punishment or charity. It is an insurance system funded through employment contributions. Treat unemployment like a structured job. One of the most effective approaches is to create a weekly routine. Example weekly structure is to apply to a set number of jobs weekly, meet state requirements, track all applications in a spreadsheet or notebook, update resume and LinkedIn profile platforms, schedule skill building or certification time, attend interviews or networking events, maintain documentation of job search activity. Many states require proof of job search efforts. Keeping records protects your benefits. Protect your mental and physical recovery. Leaving workplace abuse often comes with exhaustion, anxiety, loss of confidence, physical stress symptoms. Using unemployment wisely may include counseling or therapy appointments, medical follow-ups, rebuilding sleep and routine, career coaching, or skills training. Recovery is not laziness. It increases the chances of long-term employment success. Use available workforce resources. Most states offer free services through workforce agencies such as resume assistance, interview coaching, job placement programs, training grants or certifications, career assessments. Many people never use these benefits even though they are included with unemployment eligibility. Avoid common mistakes while on unemployment. Do not refuse reasonable job offers without cause. Report earnings accurately if working part-time. Keep copies of all unemployment communications. Meet weekly certification deadlines. Avoid social media posts suggesting you are not seeking work. Consistency protects eligibility. Sometimes a termination can open doors like unemployment or a legal claim, but it's not something you can rely on or optimize as a strategy. Being dishonest is a bigger risk than being terminated. If termination happens, you can apply for unemployment properly. Explore whether you actually have a legal case. Use the time to reset, heal, and plan your next move. You don't need your own contingency attorney if the EEOC decides to sue on your behalf. If the EEOC investigates your case and chooses to file a lawsuit, they become the legal party bringing the case. Their attorney represents the public interest and you as the affected employee. You do not pay them. There's no contingency fee from you. So you're essentially being represented at no cost. Do people still get their own attorney? Sometimes, yes, but it's optional. You might consider your own lawyer if you want more personal control over decisions. You have additional claims outside what the EEOC is pursuing. You want someone focused only on your individual outcome. But even then, it's not required. The EEOC doesn't take every case to court, often tries to settle first, conciliation. Only sues in a small percentage of cases. So if they do decide to sue, that usually means your case is considered strong and significant. Finding attorneys who work on contingency. Many employees believe legal action is impossible because they cannot afford an attorney. In employment law, that is often not true. What is a contingency fee attorney? A contingency attorney does not charge upfront legal fees, receives payment only if the case is successful, is paid a percentage of settlement or award. This arrangement allows employees access to legal representation without immediate financial burden. While some attorneys accept contingency cases, employment attorneys typically evaluate strength of documentation, evidence of discrimination or retaliation, financial damages, credibility of claims, employer size, and liability exposure. If an attorney accepts a case on contingency, it often means they believe the case has measurable legal merit. Types of workplace cases often taken on contingency: discrimination claims, retaliation claims, harassment connected to protected classes, wrongful termination tied to legal violations, wage and hour violations. General workplace unfairness alone may not qualify. Documentation connecting behavior to legal protections is key. How to find these attorneys? Research through State Bar Association law directories, employment law attorney listings, civil rights legal organizations, referrals from counseling or advocacy groups. When searching, look for attorneys specializing in employment law, labor law, workplace discrimination, wrongful termination. Questions to ask during a consultation: do you work on contingency? What percentage do you charge if we win? What costs might I owe if we lose? How long do cases typically take? What evidence strengthens my case? Should I file with a government agency first? Most employment attorneys offer free initial consultations. Prepare before contacting an attorney. Bring timeline of events, documentation log, emails, messages, performance reviews, HR communications, termination paperwork, unemployment determination letters. Preparation signals seriousness and helps attorneys evaluate quickly. Attorneys do not build cases from memories, they build cases from evidence. Your documentation becomes the foundation of any legal action. Documentation turns a personal story into a legal argument. Emotional expectation. Legal cases can take months or years. Patience. Emotional distance. The goal is not revenge, it is accountability and recovery. When workplace trauma affects your health, workplace bullying is often minimized because it does not always leave visible injuries. However, prolonged exposure to hostile environments can create real psychological, emotional, and physical consequences. Many individuals leaving toxic workplaces experience chronic anxiety, depression symptoms, panic attacks, sleep disturbances, burnout or emotional exhaustion, difficulty concentrating, physical stress symptoms, headaches, stomach issues, high blood pressure. These effects can continue even after employment ends. Leaving a harmful workplace is sometimes only the beginning of recovery. When symptoms significantly interfere with the ability to work, some individuals consider applying for federal disability benefits. Understanding SSI versus disability SSDI. In the United States, disability benefits are primarily administered by the Social Security Administration, or SSA. There are two main programs people often confuse: SSI, Supplemental Security Income. SSI is needs-based assistance. It is general relief for people who have limited income and resources, may not have extensive work history, cannot work due to medical or psychological conditions. Key features based on financial need: monthly payments may include access to Medicaid in many states, does not require long work credit history. SSI focuses on current financial and medical need. SSDI, Social Security Disability Insurance. SSDI is work history based. It is designed for individuals who previously worked and paid Social Security taxes, earned enough work credits, and now unable to work due to disability. The key features are based on priority employment contributions, monthly payments often higher than SSI, Medicare eligibility after a waiting period. SSDI functions more like an insurance policy earned through past employment. Why applying soon after leaving a hostile workplace matters. Many applicants do not realize that disability claims often consider medical timelines, onset of symptoms, continuity of treatment, ability to maintain employment. Applying sooner can help establish when symptoms begin affecting workability. Connection between workplace stress and health decline. Consistent medical documentation. Waiting too long may make timelines harder to prove. The reality: the process takes time. Understand realistic expectations. Disability applications often take 3 to 6 months for initial decisions, sometimes longer. Many first applications are denied. Appeals may take additional months or years. Patience and persistence are part of the process. Benefits of applying, even if approval takes time. Potential advantages include financial stability during recovery, access to health care coverage, documented medical validation of symptoms, structured support while rebuilding life. Applying does not mean giving up on future employment. Many people later return to work when health improves. Disability attorneys and SSI lawyers. Many disability law firms operate on contingency or regulated fee structures. This typically means no upfront payment, fees paid only if benefits are approved, fees taken from back pay awarded, regulated by federal rules. This allows individuals to pursue claims even during financial hardship. Questions to ask a disability or SSI lawyer. Interview attorneys just as attorneys evaluate cases. Important questions include: do you charge upfront fees? How are fees calculated if I win? How often will we communicate about my case? What medical evidence strengthens my claim? Should I continue treatment during the process? What happens if my application is denied? Will you represent me during appeals or hearings? How long do cases like mine typically take? Preparation helps build a strong attorney-client relationship. What strengthens a disability application? Approval is usually based on medical evidence, not personal hardship alone. Helpful documentation includes consistent medical visits, therapy or counseling records, medication history, physical statements about work limitations, hospital or specialist records, personal symptom journals. Consistency over time is extremely important. This process takes time. What worked for me may not work for everyone. Every case is different. Patience and persistence are essential, and progress may happen slowly. How unemployment, SSI, disability, and retirement withdrawals work together after leaving a hostile workplace. Leaving a toxic or hostile workplace often forces people to make fast financial decisions while under emotional stress. Many individuals simultaneously face job loss or resignation, unemployment applications, disability or SSI claims, withdrawals from 401k or pension accounts. Understanding how these systems interact can help prevent unexpected benefit reductions or denials. The financial transition after leaving employment. When employment ends due to a hostile environment, income sources may temporarily shift in stages. Final paycheck or severance, if any, unemployment benefits, retirement withdrawals, 401k/pension, disability or SSI benefits, if approved later. Each program evaluates income differently, which is why planning matters. How unemployment benefits fit into the timeline. Unemployment insurance is generally the first financial support people apply for after separation. Unemployment agencies typically evaluate reason for job separation, ability and availability to work, active job search efforts. To receive unemployment, you must usually certify that you are able and available to work. This becomes important when later applying for disability benefits. How disability benefits, SSDI, interact with unemployment. SSDI through the Social Security Administration requires proof that a medical condition prevents substantial employment. This creates a timing issue. Unemployment states you are able to work. Disability claim states you are unable to work due to medical limitations. Both can exist during a transition period, but agencies may review timelines carefully. Many individuals apply for unemployment first while attempting to recover or seek new work. If medical conditions worsen or become clearly disabling, they may later apply for SSDI. Consistency in medical records help explain this transition. How SSI is affected by income and assets. SSI is different from SSDI. because it is needs-based. SSI eligibility considers income, savings, financial resources, certain assets. This is where retirement withdrawals become very important. Withdrawing a 401k or pension. When people leave a hostile workplace, they sometimes withdraw retirement funds for survival. While understandable, withdrawals can affect benefits. Possible effects on unemployment. Retirement withdrawals may or may not reduce unemployment depending on state rules. Lump sum withdrawals are often treated differently than ongoing pension payments. Readers should always report withdrawals honestly to avoid overpayment issues. On SSI, this is critical. SSI has strict resource limits. Large withdrawals can temporarily disqualify applicants. Money kept in bank accounts may count as a resource. In some cases, funds spent on necessary living expenses reduce countable assets over time. Timing matters significantly. Timing matters significantly. On SSDI, SSDI is using not reduced but assets or savings because it is based on work credits rather than financial need. However, early retirement benefits or certain pensions may affect payment calculations in specific situations. Tax consequences of retirement withdrawals. Understand that early withdrawals from retirement accounts may include income taxes, potential early withdrawal penalties depending on age and circumstances. Unexpected tax bills can create additional stress later if not planned for. I'm encouraging you to consider speaking with a tax professional before withdrawing large amounts when possible. Why documentation still matters financially. If leaving due to a hostile work environment, documentation can help explain why employment ended, why retirement funds were accessed, how stress affected ability to continue working. This context may become relevant during unemployment hearings or disability evaluations. A common real-life timeline. Let me give you a scenario like Stage 1, employee leaves hostile workplace. Stage 2, applies for unemployment while seeking work. Stage 3, uses limited retirement funds for survival expenses. Stage 4, medical symptoms persist or worsen. Stage 5, applies for SSI or SSDI with medical documentation. Stage 6, attorney assists with disability claim if needed. Transitions are often gradual, not immediate. Benefits and risk of using multiple support systems. The benefits are financial stability during recovery, access to healthcare coverage, time to heal and rebuild, reduced pressure to return to harmful environments. The risk, benefit delays, income reporting requirements, asset limits affecting SSI, misunderstandings between programs. Awareness helps prevent surprises. Patience and planning. Recovery after workplace harm is often a process, not a single decision. Financial systems move slowly, but preparation and honesty help protection long-term stability. Before withdrawing retirement funds, consider, will this affect SSI eligibility? Have I applied for unemployment first? Do I understand tax consequences? Can I consult a financial or legal professional? Am I documenting why funds are needed? After leaving a harmful workplace, I had to make difficult financial decisions while trying to recover emotionally and mentally. Every system, unemployment, disability, and financial planning require patience. What worked for me may not work for everyone, but understanding how these systems connect made a difference. Using lump sum money wisely after leaving a toxic workplace. After leaving a hostile or harmful work environment, many people face sudden financial uncertainty. Some individuals may receive access to lump sum funds such as 401k withdrawals, pension payouts, severance pay, accrued vacation payouts, settlement funds if available. These funds can feel like relief, but they also represent a critical turning point. The goal is not just survival. The goal is financial stabilitation while rebuilding your life. Think of lump sums as protection, not spending money. A lump sum is often replacing future income you no longer have, treating it as temporary protection instead of extra cash can prevent long-term financial stress. A helpful mindset, this money is being timed stability and peace, not lifestyle upgrades. Priority strategy, reduce monthly obligations. One of the most stabilizing uses of lump sum funds is lowering required monthly expenses. Many people choose to focus on catching up or getting ahead on mortgage payments, reducing or paying down car loans, eliminating high interest debt, covering essential bills in advance. Lower monthly obligations create breathing room while searching for new employment, waiting for unemployment decisions, pursuing disability or legal processes, recovering emotionally and physically. Why reducing fixed expenses matters. Financial stress often comes from monthly payments, not total debt. For example, a smaller car balance equals a lower monthly pressure. Mortgage payments paid ahead equals housing security. Debt reduction equals fewer financial emergencies. Reducing required payments can extend financial stability for months or even years. Budgeting once regular income begins again. When unemployment, disability benefits, or new employment income begins, carefully budgeting becomes essential. Helpful budgeting principles to include separate needs from wants. Focus first on housing, utilities, food, transportation, and health care. Delay non-essential spending until income stabilizes. Create a stability budget. Instead of budgeting for comfort, budget for consistency. Ask what expenses must be paid every month, no matter what. How long can current income cover these essentials? Avoid lifestyle inflation after crisis. It is common to overspend once income resumes because of emotional relief. I encourage you deeply to rebuild savings gradually, maintain simpler spending habits temporarily, prioritize emergency funds, track every dollar initially. During transition periods, awareness matters more than perfection. Simple tracking methods, notebook ledger, budgeting apps, weekly expense review. Visibility prevents financial surprises. Emotional spending awareness. Leaving a toxic workplace can trigger emotional spending due to relief, exhaustion, desire to reward oneself, reclaiming control. Temporary discipline protects long-term stability. A helpful reminder, financial peace supports emotional healing, balancing immediate needs and future security. Consider balance. Paying down essential debts may reduce stress. Completely draining retirement savings may affect long-term security. Every situation is different, and decisions should reflect individual needs and timelines. When possible, consider professional guidance. If available, you may benefit from consulting financial planners, tax professionals, retirement advisors. Even a single consultation can help avoid unexpected tax consequences or benefit conflicts. Before spending a lump sum, ask, does this reduce my required monthly bills? Will this help me stay housed and mobile? Am I preparing for income gaps? Have I considered taxes or penalties? Does this decision create long-term stability? During my transition, I learned that financial stability creates emotional stability. Using available funds wisely helped me reduce stress while rebuilding my life. What worked for me may not work for everyone, but thoughtful planning made a difficult season more manageable. Freedom after a toxic workplace begins with lowering the bills that keep you trapped. Legal disclaimer. This book is based on personal experience, research, and general informational purposes only. It is not intended to provide legal, medical, financial, or professional advice. The author is not an attorney, physician, or licensed professional acting in a professional capacity. Laws, regulations, and individual circumstances vary widely, and readers should consult qualified professionals regarding their specific situations. Nothing in this book guarantees outcomes related to employment disputes. unemployment benefits, disability claims, or legal actions. The strategies and experiences described reflect personal experiences and may not produce the same results for every individual. Readers are encouraged to seek professional, legal, medical, and financial guidance before making decisions that may affect their rights or benefits. Healing after a toxic workplace is not weakness, it is recovery. Seeking support is not failure, it is strategy.